Good morning, I'm Craig Mueller, Mr. McDonald, defense registry. Once again, I want to object to the presence of the cameras in the courtroom. If I may be heard as the cameras.
Go ahead.
Yesterday, at about this time, we were at Judge Silva over District Court 9. The same film crew was present in that courtroom. Judge Silva specifically directed the cameraman on Monday, Mr. Falcone, not to air or show any of the proceedings. She reasoned as simply as you did that the word media has to be adjusted with the changing technologies. I concede it's a good, valid point. Having said that, the judge instructed Mr. Falcone not to air the opening statements until the witnesses had been on the witness stand. By mechanisms that's still not completely known, two of the three witnesses were showing the arguments of opening statements. They then volunteered to come down at about 10 o'clock on Monday evening to help the prosecutors with additional evidence. Judge Silva declared a mistrial as a result of the cameraman's violating the court order. We have another hearing today at 1:30 for Mr. McDonald's custody status, and I will be filing a motion again to change the mistrial from without prejudice to with prejudice. It is against that background I feel compelled to ask for continuation of this sentencing. I'm going to ask Mr. McDonald to be given an owner cognizance release. And we're going to ask for an appointment of an investigator and investigate whether there was contamination of this particular trial through the mechanism of this courtroom or through these cameras. I have complained, and I candidly am tired of hearing myself having to say this, but the record has to be made. These have been the most extraordinary proceedings I have been party to as a criminal defense lawyer in going on 30 years now. This is the first time I've seen a detective get on a witness stand and say something that I know was specifically not true. This was the first time I had a detective get on a witness stand and say, I found the investigation, the allegations were not true, but I continued to investigate the defendant anyway. This is the first time in my life I've seen the state attempt to
Counsel, what is it? I
Okay.
allowed you to have
Okay.
your hearing regarding the cameras,
I
but
believe
as far as the sentencing, then we need to start that.
Okay, thank you, Judge. I believe that these proceedings have been contaminated by the presence of these cameras, these courtrooms. There are cameras in the courtroom based on the facts that they were reduced in Department 9. I believe it's the ends of justice warrant releasing Mr. McDonald, sentencing a new sentencing date, and giving me an opportunity to investigate, and I may have to petition the court for appointment of an investigator. But this verdict has been contaminated, and I believe through improper exposure of the courtroom testimony to the witnesses, and certainly to a reasonable inference, and it needs to be investigated.
But you have no evidence of that, just because in another case over almost 90 days ago, I believe, was when we did our trial.
Yesterday was?
No.
Okay.
That case was whatever. But you have no information at all regarding our case, correct?
I stood on a courtroom Monday and watched Judge Silva tell a man not to do something, and then saw him go out and do it directly, contaminating the verdict. That was yesterday.
State.
And Your Honor, obviously the state would oppose any continuation of the sentencing. Anything that occurred in the other case in front of Judge Silva has no bearing on this sentencing going forward, and is not a basis for continuing the sentencing. And I'll just briefly correct the record. The same organization was filming the trial that was in Department 9. After opening statements were concluded, defense counsel did make the request that the video of opening statements not be posted until the trial was completed. Judge Silva granted that request. The organization did not inform Judge Silva that the opening statements had been live streamed. The state was unaware that two of its witnesses had actually watched opening statements, and none of the witnesses volunteered to come down at 10 o'clock at night and help the state. One of those witnesses did then email some information and some evidence to my co-counsel, which was relevant to the case, and we provided that to Mr. Mueller. But due to that being a late disclosure of evidence, that was the basis for the mistrial being granted. Judge Silva specifically stated she was not granting the mistrial on the basis of the cameras. It was on the basis of information that had been provided at a late date. Additionally, there is simply no basis for continuing the sentencing in this case on this basis, and I wanted to also note the motion which defense counsel filed. I was not served with it at all. but I did review it. Candace Ruiz was not a witness in this case. He stated that she was the main witness in this case and is one of the witnesses involved. The witnesses involved who watched the opening statements in the other case did not testify in this case. We had a completely different set of witnesses, the majority of which don't even really know the defendant, half of which were law enforcement.
Mr.
In rejoinder, Judge, I have 1, 2, 3, 4, at least 4 or 5 witnesses have written to you on behalf of Ms. Candace Ruiz, Mr. McDonald's ex-wife. She's not, as my colleague just pointed out, she's not even involved in this case. That she bears him ill will is not meaningfully in doubt. In fact, her lawyer's here in the courtroom. She's been in every one of these criminal proceedings. Now, this has been...
Well, again, that has to do with sentencing.
Well, yes, I'm going to have...
Tell me if you have any rebuttal regarding continuing the sentencing today.
Yes, I now have 4. I've got to figure out why I've got 4 witnesses that have come in on a case that my colleague said the witness wasn't a part of, and is now having and asking the court to impose maximum sentences on Mr. McDonald. The bile literally drips off these letters from his wife and his ex-wife and her friends. I have not had time to review these letters or investigate them. I'd also like to figure out by what mechanism they're even relevant, and I'm going to either put into writing a motion to exclude them or to ask the court to exclude them as they are not relevant to the issues, as my colleague has just conceded. Now, this...
I tend to agree with you, but again, what does that have to do with going forward with the sentencing today?
Well, as a court of the
If you want to ask when we get to that they be excluded, I think you're absolutely right.
All right, thank you. I would like to continue this to I can investigate what exactly happened with this camera crew. This is a very unusual case. The court's well aware. I believe he should be given an own recognizance, and I asked to set the sentencing up. They're recommending probation. He's got 533 days in, Judge. It's not like...
That is not correct, and I don't know if Your Honor saw the supplemental.
All right, no, thank you. All right, as far as continuing the sentencing, this has been, I believe, as I said before, almost 3 months since the trial, and certainly had you wanted to file some sort of a motion regarding that, you certainly could have. What happened in this new trial doesn't require or suggest that we should delay sentencing in this trial. I don't have any, not just authority, but even knowledge of what is going on there. And again, you have options after that, but to delay sentencing further, I just don't see any grounds. And as far as the camera crew, I have said and repeated, and I understand you've clearly made your record several times regarding your disapproval of the camera crew. Our Supreme Court has said that the presumption is we have an open court, and that certainly the media, and that's a broad term. We went over this and I spent probably 10 minutes during the trial and since, etc. But for the record, I'll do it again. The media, that's a broad term, and our Supreme Court has said that the media can be present except for unusual circumstances. There haven't been any grounds to exclude the media that I've been presented with, and so based on all of that, I'm allowing the media, and we're going to go forward with sentencing today.
An absolute decree of divorce is granted.
By September 6th, you will pay $6,000 of what is due.
I make a finding that paternity has been established.
He was a potential danger to his children.
We're here for the court's order to show cause. Okay, so that takes care of one motion.
You will make sure that she's put on house arrest.
As you know, the Supreme Court has state.
Thank you, Your Honor. I want to note at the outset, in the original PSI, the department incorrectly stated his credit for time served was over 500 days. They seem to, you probably noticed this yourself, but I wanted to make it clear for the record. I notified them and they did a supplemental PSI, the only change being they corrected the credit. He has 117 days credit for time served.
I've never seen this supplemental PSI.
Would you like an extra copy?
Yes.
And for the record, when I looked at it, the only difference in the supplemental PSI was the correction to the credit for time served. So correcting it from over 500 days to 117 days.
No, he should have more than 117 days in because I had him remanded into custody. I actually put it on a calendar and had him remanded in custody concurrent with the misdemeanor. That's another 180 days that are unaccounted for. So.
And Your Honor, I believe the number of days here are correct.
All right, we can get to that. I knew when I saw the first one that it wasn't 500 days, which would be close to 2 years. All right, go ahead.
And Your Honor, I request today that you give the defendant a prison sentence. I realize that the department is recommending probation, but that is clearly based upon the formula that the department uses, which heavily weights a defendant's lack of felony history. And despite his lack of felony history, the defendant, over the past year and a half, has demonstrated that he will not be successful on probation if he's given it. He is entirely unsupervisable. There's no question that if given probation, he will not follow the rules, no matter how clear, and he'll violate, and ultimately he'll end up in prison anyway, most likely after hurting someone. And I won't belabor the facts of the instant case, because you presided over the trial, but I want to discuss some things that could not be brought up at trial. I was informed by Timothy Spees, one of our witnesses at trial, who has been a marshal at family court for a long time and is very familiar with the defendant. He once found the defendant to be carrying a knife on his person when he was entered.
I'm supposed to be allowed to see what evidence is going to be presented in an argument. Now, I've already moved to exclude these letters. Now I've got a hearsay account.
And Your Honor, I object to interrupting my argument.
Well,
this is sentencing.
Sentencing on a trial is
Yes,
done.
but hearsay.
This is completely inappropriate.
Hearsay admission, are asking me to consider information that's totally outside the record. I certainly never had it. I don't think you saying what he's told you outside of what he testified is appropriate, so I'm gonna exclude that. Go ahead.
And Your Honor, the defendant has a lengthy history of not respecting court orders. 3 times he's been convicted in Las Vegas Municipal Court of violating restraining orders against his ex-wife. He pleaded no contest to the 2017 count, which included a requirement of no contact with his ex-wife other than through talking parents. And he's repeatedly had issues with contacting his ex-wife in various creative ways. And importantly, when his suspended sentence for one of those counts was imposed in municipal court, he fought with the marshals very violently. I've seen the video of him doing so, and that resulted in his conviction for resisting arrest. And we all know he did the same thing in this very courtroom on July 22nd when he was remanded in this case. Okay, I was there. 2 marshals weren't enough. They had to call for backup in order to put him in handcuffs. He clearly has huge problems with authority. He just doesn't respect the rules that he's given. He doesn't respect the judicial system, and that's why he would not be supervisable on probation. And again, why was he being remanded in the first place? For violating the court order and making contact with his ex-wife, Candace. And I want to note that the PSI mentions his BDB arrest and puts no disposition. The paperwork that I have shows that in addition to his misdemeanor convictions for resisting arrest and violating restraining orders, he was also convicted of misdemeanor battery domestic violence in January 2017 in case C1166005B. And so, despite defense counsel repeatedly saying he has no history, he actually has quite an extensive misdemeanor history at this point. Additionally, there were certain findings that Judge Markey made in family court that I think are relevant to whether or not he would be supervisable. I know they're not things that were introduced at trial, but they're things that I've witnessed.
Objection. Judge Markey wanted nothing to do with this.
Well, if they're part of the court record, then I think they are admissible.
Okay, so that's the reason I bring them up. Judge Markey, throughout the family court hearings, stated that the defendant had put a tracking device on his ex-wife Candace's car, as well as disabled the engine of her vehicle. In November of 2016, the defendant was found to have violated the restraining order by entering his daughter's daycare facility and initially picking up the wrong child.
Again,
After-
this is
Excuse
not
me.
the record. This is nothing but
All right,
hysteria.
counsel, you can object and then make your objection. Mr. Mueller, do you have an objection?
Yes, beyond the scope and it's outside the record.
It's apparently in the court record from family court, which I think is admissible. Is that what you're referring
Yes,
to? Go
yes, I'm
ahead.
referring to the record from family court that I
Go
reviewed
ahead.
in the course of this case. Okay. And that incident was the basis for I believe, his second conviction for violating a restraining order. The police were called when he wouldn't leave the daycare. Additionally, I brought this up when he was remanded before. Judge Hardcastle did find it relevant. The defendant showed up at a CLE for the district attorney's office, and he became aggressive with Nell Christensen and stated that he wanted to attend all of our CLEs and then ran off with our CLE schedule. Nell Christensen was very bothered by this particular interaction, and it was a concern to our investigators, who then had to increase security for our CLEs. Additionally, and this also comes from the family court, when Judge Markey was overseeing his family court case, the defendant contacted Judge Markey's husband, who's an attorney in town, and talked to him about hiring him. They have the same last name. It was pretty obvious that he knew he was contacting the judge's husband. It's unclear what he was trying to do, if he was trying to get information about Judge Markey or if he wanted to create a situation in which she would have to recuse herself. But according to the record Judge Markey made, I watched this on video, the defendant called Judge Markey's husband and told him what department his family court case was in. Her husband said, well, I can't appear in that department, can't help you. The defendant kept trying to keep him on the phone and asking him to take his case. Those were the findings Judge Markey made regarding that. Additionally, additional security precautions were taken regarding him contacting Judge Markey and her husband. And additionally, when this initially happened, I didn't think that much of it, but in combination with his other behavior, it concerns me more now. He, back in April, when the defendant was initially released on house arrest in this case, as J.P. Rahman, my co-counsel in the defendant's other case, and I were leaving the Clark place in the crosswalk, the defendant suddenly appeared walking in the crosswalk toward us and approached us. And he stated hello, hey, and said something along the lines of, it would be nice if you stopped maliciously prosecuting me, and then just kind of laughed and walked on. I didn't really think much about it, but in combination with his tendency to contact people who are connected with his case, it's kind of concerning for me. And I find it kind of offensive that he's acting as if this entire case were a joke by laughing at it. Additionally, I reviewed his records from CCDC. He's had some disciplinary issues there as well. He's been placed in disciplinary housing, commonly referred to as the hole, for not following orders. He initially refused to submit to a strip search, which was required after he was leaving the program, and he argued with the corrections officer, stating that it was a violation of his constitutional rights. As a result, he was placed on lockdown. He didn't comply with the lockdown by being in the cell where he was supposed to be. So again, this is indicating he's not going to comply with authority. He would not be successful on probation. And returning to the case at hand, what's particularly odious in this case is the defendant's perjury. As we know, the defendant testified before family court that he was unemployed and had no income other than a small amount through odd jobs. And in reality, he had a full-time salaried position. And we all know what his motive was for doing that. He didn't want to pay child support. He wasn't, excuse me.
I object to that statement. It's not in the record.
It's argument.
All right.
It is in the record. This was the video that was introduced at trial.
Yes, I saw it. Continue. Overruled.
He wasn't confused or nervous. We all saw the video of him testifying under oath. He was quite calm. He clearly stated, very sadly, that he had been unemployed for forever. He knew that what he was saying wasn't true. Contrary to defense arguments, he wasn't confused, and he didn't have an attorney because his attorney had killed himself. He had an attorney 2 years prior to this, whose death was ruled a suicide in 2016. At the hearing in which he perjured himself was in 2018, and his attorney actually showed up at the beginning of the hearing and withdrew, stating that he felt he could no longer continue representing the defendant due to them having different ideas about how to proceed with the case. I mean, further, the defendant has been stating that he's been working for defense counsel as a paralegal. Okay, he's not someone who's entirely unfamiliar with the concept of perjury. He knew that that was what he was doing. And he repeatedly states that his motives for this are that he just wants to see his kids, but his actions are not the actions of someone who just wants to see his kids. A great way to make sure that you get to see your kids is to not commit perjury, not lie about the money that you have that you can use to help them, to not submit forged documents to the court, to abide by court orders. If he really wanted to see his kids, if that were what was driving his behavior, then he would have behaved very differently. And repeatedly it's been argued that this was a political prosecution when it simply was not. And defense counsel has repeatedly attempted to downplay the defendant's actions by saying, well, it doesn't matter because it all happened in family court. Family court is not some alternate universe in which actions have no moral or legal consequence. Nothing could be further from the truth. And nothing that happened here was the fault of the defendant's ex-wife, Candace. She had nothing to do with this case coming to the attention of the police or the DA's office. There's no doubt that tempers and emotions run high in family court. Maybe most people aren't really at their best selves when they're appearing there, but the defendant wasn't prosecuted for getting confused or losing his temper or getting upset. He was prosecuted for being a liar. He lied to the court. He did so repeatedly. He did so blatantly. And he publicized his actions himself by putting all of these hearings on the internet. His actions are his fault and no one else's, and they're highly offensive. And I ask that you give the defendant pardon and that you impose a sentence of 24 to 60 days. And I want to again note for the record that he only has 117 days credit for time served. And with that, I'll submit.
Thank you, Mr. McDonald. Before your attorney speaks on your behalf, is there anything you'd like to say?
There's a lot of things. Okay, Mr. McDonald.
Yeah.
Your Honor, I misspoke, it's the 24 to 60 days, I meant 24 to 60 months.
Judge, there's a lot I'd like to say to bring up to your attention that we've never brought up, but I'm under advisement of counsel, and just like you said, that I apologize for this case even coming before this court. They should have stayed again before. I'm sorry. Just wanted to.
Thank you, Mr. Mueller.
Your Honor, with deference to my colleague who's never appeared.
Counsel Judge.
Thank you, Your Honor. Pursuant to the conversation at the bench, we'd accept the court's proposal.
All right, then I will continue this for Mr. Mueller to apply to mental health court. It is I'm told, a 1 to 3 year program, but it's my understanding it is successful. They will monitor if in fact he's accepted. And it's not simple. I don't want to, I think maybe Mr. Mueller, you're as familiar as I am with it, but in any event, it's 1 to 3 years of constant supervision along with making sure that appropriate meds or whatever. So, all right, I'll give you 3 weeks to, I think that's plenty of time to apply.
We'll get it done sooner, Judge. We'll get 2 weeks. I'd like to get this done.
All right, 2 weeks, defendants remain in custody, and we'll continue this to see what,
right there, a second.
see what they say. All right, thank you. 2 weeks is what?
That's January, or November 13th, 9 a.m.
All right, thank you.
And Your Honor, is the defendant's OR motion or motion off calendar for now?
It's off calendar, yes.
Thank you, Your Honor.
Why don't we all go this way?
Just a second, guys. Just a second.